Hello friends, I am Jagdish Khobragade, Assistant Professor, School of Law, Dr. HARISINGH, GOUR, VISHWAVIDYALAYA, SAGAR, Madhya Pradesh. Today's topic of our discussion and learning is about Constitution of India. But before I move ahead to the introduction of this discussion, let me introduce about what we are going to learn today. Today's lecture is divided into following modules. Module 1, Introduction. Module 2, Preamble to the Constitution of India. Module 3, Fundamental Rights, Article 14, 15, 20. Module 4, again Fundamental Rights, Article 21 and 22. Module 5, Directive Principles of State Policy, and Module 6, Fundamental Duties. Let us start with introduction. Today we are going to learn about the Constitution of India. Though it is very vast and complex to understand, but we will try to make it simple. First, we will discuss about brief introduction of the Constitution of India. Then what is Preamble to the Constitution of India, why fundamental rights are very important to us, and why the people of India given this document to us, what are directive principles of state policy, and lastly, what are the fundamental duties of citizen of India. As we know, India got independence on 15th August 1947. The Constituent Assembly, which came into existence on December 9, 1946 under the chairmanship of Dr. Rajendra Prasad. The Constituent Assembly set up a drafting committee under the chairmanship of Dr. B.R. Ambedkar to prepare a draft of the Constitution of India. Thereafter, under the chairmanship of Dr. B.R. Ambedkar, the draft of the Constitution became ready by 14th November 1949, and the Constituent Assembly finally approved it on 26th November 1949. Therefore, it is also called a Constitution Day. And lastly, it came into effect on 26th January 1950, which is called the Republic Day of India. The Constitution of India is the basic and supreme law of our country. Indian Constitution basically gives two things to the people of the country. One, a legal system to the country, and second, the legal rights to the people. Every country has to run its administration, and the Constitution of India provides the method of that administration. For example, how to run a government in democratic manner. We call it as a legal system. We have some basic fundamental rights under the Constitution of India, but by which we can go to the court for violation of those rights. It is called legal rights to the people. The Constitution of India is basically federal, but with certain unitary features. Therefore, sometimes it is called quasi-federal and quasi-unitary form of government. The Constitution of India provides three organs of government. For example, executive, judiciary, and legislature. Apart from dealing with the structure of government, the Constitution makes detailed provisions for the rights of citizens and also provides provisions for public authorities, legislative, administrative, and judicial. The objective of this lesson is to make the student understand the basic framework of the Constitution of India and rights of citizens. Now under chapter 2, we are going to discuss about Preamble of the Constitution of India. The Preamble to the Constitution sets out the aims and aspirations of the people of India, which says that we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. it is mentioned in the preamble that the Constitution of India has been adopted by the people of India on 26 November 1949. The words socialist and secular added by the 42nd Amendment to the Constitution in 1976, which aims to secure to its people justice, social, economic and political and religious freedom to all. The expression Democratic Republic signifies that our government is of the people, by the people and for the people. In a famous case of Keshwanand Bharti versus State of Kerala in 1973, the Supreme Court held that the preamble is the part of the Constitution of India. In another famous case of Minerva Wills versus Union of India in 1980, the Supreme Court provided clarification on the interpretation of the basic structure doctrine. The court by majority held that Parliament's power to amend is not power to destroy. Hence, the Parliament cannot reduce the fundamental rights of individuals, including the right to liberty and equality. Now, under chapter 3, we will discuss fundamental rights, particularly article 14, 15 and 20. But first, we will discuss article 12. As there are some basic natural rights which cannot be taken away from the people, the Constitution seeks to secure to the people of India the same rights, that is liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and fraternity, assuring the dignity of the individual. With this object, the fundamental rights are envisaged in the part 3 of the Constitution. Inclusion of fundamental rights in part 3 guarantees 6 categories of fundamental rights. These are right to equality under articles 14 to 18, right to freedom under articles 19 to 22, right against exploitation under article 23 and 24, right to freedom of religion under articles 25 to 28, cultural and educational rights under article 29 and 30, right to constitutional remedy under article 32. Apart from this, there are some supplementary rights which are provided under articles 31 to 35, but we are going to discuss some of them in the following discussion. Firstly, we will discuss about article 12, which is very important article because all the fundamental rights are available against the state. Therefore, we must know what is the state. Under article 12, unless the contest otherwise requires, the state includes the government and Parliament of India, the state government and all local or other authorities within the territory of India or under the control of the government of India. The expression local authorities refers to authorities like municipalities, district boards, panchayat, improvement trust, port trust, mining, settlement boards, etc. In the case of Electricity Board Rajasthan versus Mohanlal in 1967, the Supreme Court held that other authorities will include all authorities created by the Constitution or by any statute. In another 2 cases of Sukhdev Singh versus Bhagat Ram in 1975 and R.D. Shetty versus International Airport Authority in 1979, the Supreme Court has pointed out that corporations acting as instrumentality or agency of government would become state. Now, secondly, we will see article 14, which provides equality before the law and equal protection of the laws. Article 14 of the Constitution says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The expression equality before the law, which is borrowed from English common law, which means that all persons are equal before the law and no person has special privilege under any law. The second expression, the equal protection of the laws, which is based on the American Constitution, which directs that equal protection shall be secured to all persons within the territorial jurisdiction of the Union, and in the enjoyment of their rights there shall not be any discrimination. it is interesting to know that Article 14 applies to all persons and is not limited to citizens only. As a matter of fact, all persons are not alike or equal in all respects. Application of the same laws uniformly to all of them is not possible. Therefore, it is inconsistent with the principle of equality. In fact, that would itself lead to inequality. Therefore, equality is a relative concept. Legislative classification is important under Article 14, which provides that reasonable grounds of distinction is necessary. Since distinction is to be made for the purpose of enacting a legislation, it must pass the classical test provided by the Supreme Court in the state of West Bengal versus Anwar Ali Sarkar in 1952. After considering leading cases on equal protection clause enshrined in Article 14 of the Constitution, the 5-judge bench of the Supreme Court in Confederation of Ex-Servicemen Association versus Union of India in 2006 held that permissible classification must satisfy two conditions. Namely, first condition, it must be found on an intelligible differentia which distinguishes a person or thing that are grouped together from others, and second, the differentia must have a rational nexus with the object sought to be achieved by the statute in question. As we know, Article 15 is very debatable topic in India, which prohibits the state from discriminating against any citizen on grounds of religion, race, caste, sex, place of birth or any of them. And Article 15 clause 2 lays down that no citizen shall be subjected to any disability, restriction or condition which regard to entry into shops, hotels and public places. However, Article 15 clause 3 and Article 15 clause 4 create certain exception to the Article 15 clause 1 and 15 clause 2. Under Article 15 clause 3, the state can make special provision for women and children. Article 15 clause 4 permits the state to make special provision for the advancement of socially and educationally backward classes of citizens, scheduled caste and scheduled tribes. The first case, which was considered to be the leading case, was Balaji versus State of Mysore in 1963. In this case, the Supreme Court has laid down principles which are accepted as good law till this date. The fact of the case are that Mysore government has provided reservation in engineering and medical colleges. The percentage of reservation which was fixed by the government was 68%. This 68% included the reservation for SC, ST and backward classes and more backward classes. But this was challenged by the Balaji as excessive reservation. He has contended that such reservation has defeated the very purpose of equality. It was held by the Supreme Court that as per the provision of the Constitution, the state cannot reserve the seats for socially and educationally backward classes up to 50% and not more than that. If reservation is provided for more than 50%, then it would defeat the very purpose and provision of equality under the Constitution. Hence, in no case the reservation should be exceeded more than 50% at a time. In another two famous cases, that is Indra Swahney versus Union of India, which is also called Mandal Commission case in 1992, and Ashok Kumar Thakur versus Union of India in 2008, the Supreme Court has held that a report of Mandal Commission was valid and has recommended 27% reservation for other backward classes. However, a total reservation including SC, ST shall not be 50% and in no event the quantum of reservation shall not extend beyond 50% at a time. Otherwise, the reservation should be declared as bad in law. Now, we will discuss about Article 20, that is protection in respect of conviction for offences. Article 20 guarantees to all persons, whether citizens or non-citizens, 3 rights, namely 1. Protection against ex post facto laws, 2nd. Double jeopardy, 3rd. Protection against self-incrimination. According to Article 20 Clause 1, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of an offence, and nor be subjected to greater punishment than what might have been inflicted under the law in force at the time of commission of an offence. For example, what was not an offence in 1972 cannot be declared as an offence under a law made in 1974, giving operation to such law from backdate. Even the penalty for the commission of an offence cannot be increased with retrospective effect. For example, suppose for committing a dacoity, the penalty in 1970 was 10 years imprisonment, and a person commits dacoity in that year, and by law passed after his committing the dacoity, the penalty for his act cannot be increased from 10 to 11 years or to life imprisonment. Now we will see the protection against double jeopardy. According to Article 20 Clause 2, no person shall be prosecuted and punished for the same offence more than once. For example, you might have seen the movie called Andha Kanun, in which the Amitabh Bachchan killed a person before the judge, and for that offence he has already spent 20 years in jail. Therefore, the court cannot punish Amitabh Bachchan for the same offence more than once. Now we will see protection against self-incrimination. According to Article 20 Clause 3, no person accused of any offence shall be compelled to be a witness against himself. In other words, an accused cannot be compelled to state anything which goes against him, but it is to be noted that a person is entitled to this protection only with certain conditions. Now under Module 4, we will discuss fundamental rights, and specially Article 21 and 22. Chapter 4 provides that Article 21 confers on every person the fundamental right to life and personal liberty. It says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. The right to life includes many things which are related to every corner of life. For example, right to live with human dignity, right to health, right to food, etc. And the first contribution to the development of Article 21 came in 1950, when the communist leader A.K. Gopalan was arrested under the preventive detention law. A.K. Gopalan was detained under preventive detention, but he challenged his detention on the ground that his detention is violated due process of law. He pleaded that the concept of due process under the American Constitution and the phrase procedure established by law under Article 21 of Indian Constitution are one and the same thing, but the Supreme Court held that the procedure established by law and due process are different terms. However, this very Supreme Court in 1978, while deciding the case of Menaka Gandhi versus Union of India, very specifically observed that the concept of due process of law and the procedure of established by law are not different terms. The court also held that the law made by Parliament has to be just, fair and reasonable. The concept of personal liberty has been discussed in many cases, but we will see few of them. For example, HARISINGH versus State of Uttar Pradesh in 1963. In this case, the police department kept watch on HARISINGH's house for establishing his link with dacoit. In the course of police surveillance, the police used to knock the doors at night, which disturbed the Kharak Singh. Hence, he filed a petition on the ground that he has right to privacy under Article 21 and which cannot be taken away by the police or so called state. The Supreme Court held that the right to privacy was not provided under Article 21 and no relief granted to Kharak Singh. But the very Supreme Court after 1980 has declared in many cases that right to privacy has included in Article 21 of the Constitution of India. In the case of Menaka Gandhi versus Union of India in 1978, the Supreme Court held that a personal liberty within the meaning of Article 21 includes within its ambit the right to go abroad, and no person can be deprived of this right except according to procedure established by law. After this decision, the Supreme Court has extended the scope of Article 21. Now again we will see Article 22, which is also an important article under the Constitution of India, which provides protection against arrest and detention. But before we discuss about this provision, we must know the meaning of preventive detention. Preventive detention means a detention of a person without trial. The object of preventive detention is not to punish a person for having done something, but to prevent him from doing it. Article 22, Clause 1 and Clause 2 provides for safeguard for person who is arrested, that a person who is arrested cannot be detained in custody unless he has been informed the grounds of such arrest. Second, such person shall have the right to consult his legal practitioner of his choice. Number 3, a person who is arrested and detained must be produced before the nearest magistrate within a period of 24 hours of such arrest and excluding the time of journey. And number 4, such person shall not be detained in custody beyond 24 hours without the authority of magistrate. However, these safeguards are not applicable to an alien enemy or a person is detained under preventive detention law. Article 22 has been amended by 44th Amendment to the Constitution in 1978, which contains following safeguards against preventive detention, that a person cannot be detained for a longer period than 3 months unless an advisory board should be constituted for such detention. Second, Parliament by law may prescribe the maximum period for which any person to be detained under preventive detention, and the authority ordering the detention of a person under preventive detention law shall communicate to him as soon as may be the grounds on which the order for his detention has been made, and afford him the earliest opportunity of making the representation against the order. However, it may be noted that while giving grounds for making arrest are to be supplied to the person arrested, and if necessary, it should not disclose such facts which are in the interest of public. Now we will discuss about directive principles of state policy. The articles included in part 4th of the Constitution, that is articles 36 to 51, which contains directive principles which are the guidelines for the government. Article 37 provides that the provisions contained in this part shall not be enforceable by any court, but the principles therein are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. These principles are borrowed from the Constitution of Ireland. In the Irish Constitution, these principles are enforceable in the court of law. But in our constitution, directive principles are not enforceable in the court of law. It means no person can challenge these principles into the court of law on the ground of that they are not followed by the state. The directive principles are related to fundamental rights. The fundamental rights are enforceable in the court, while directive principles are not enforceable in the courts. In the beginning of the rule of constitution, the directive principles and fundamental rights were treated differently. But in the case of Champakam Dorairajan versus State of Madras, for the first time the question was raised that the case of conflict between directive principles and fundamental rights, which should prevail. It was held that the fundamental rights prevail and directive principles will have to give way for fundamental rights, because fundamental rights are enforceable and directive principles are not enforceable. But the same Supreme Court in many cases, including the case of State of Gujarat versus Mirzapur Moti Qureshi Kasab Jamat in 2007, has interpreted that the directive principles and fundamental rights were treated equally and they have same importance. Now we will discuss some of the important directive principles, which are as follows. Article 38 provides that the state should secure a social order for the promotion and welfare of the people. Article 39A provides free legal aid and equal justice. Article 40 provides organization of village panchayats. Article 41 provides right to work and right to education and right to public assistance in certain cases. Article 42 provides provision for just and humane conditions of work and maternity relief. Article 43 provides living wages for workers. Article 43A provides participation of workers in management and industry. Article 44 provides uniform civil code for citizens. Article 45 provides provision for free and compulsory education for children up to the age of 14 years. Article 46 provides promotion of education and economic interest of scheduled caste, scheduled tribe and other weaker sections. Article 47 provides duty of state to raise the level of nutrition and standard of living to improve public health. Article 48 provides organization of agriculture and animal husbandry. Article 48A provides duty of state to protect and improve environment, forest and wildlife of country. Article 49 provides protection of monuments and places of national importance. Article 50 provides separation of judiciary from executive, and lastly Article 51 provides promotion of international peace and security. Now under chapter 5th we will discuss fundamental duties, which are duties of you and me. Article 51A was inserted by 42nd Amendment to the Constitution in 1976. There are 11 fundamental duties from clause A to clause K, and all duties are important for the citizen of India. These are as follows. A. To abide by the Constitution and respect the national flag and national anthem. B. To cherish and follow the noble ideals which inspired our national struggle for freedom. C. To uphold and protect the sovereignty, unity and integrity of India. D. To defend the country and render national service when called upon to do so. E. To promote harmony and the spirit of common brotherhood amongst all the people of India, and to renounce practices derogatory to the dignity of women. F. To value and preserve the rich heritage of our composite culture. G. To protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. H. To develop the scientific temper, humanism and the spirit of inquiry and reform. I. To safeguard public property and to abjure violence. J. To strive toward excellence in all spheres of individual and collective activity. K. To provide opportunities for education to every child between the age of 6 and 14 years. And in Surya Narayan versus Union of India in 1982, the Supreme Court held that the duties are imposed upon the citizens, but the fundamental duties cannot be enforced by the writ petition. In another case of AIMS Students Union versus AIMS in 2002, the Supreme Court has held that though the fundamental duties are not enforceable by the courts, they provide a valuable guide and aid to the interpretation of constitutional and legal issues. At last, to conclude with this lecture, I must say that the Constitution of India is the supreme law of the land. The fundamental rights enshrined in the Constitution are subjected to certain restrictions because absolute freedom leads to mockery of democratic system. The directive principles of state policy are for good governance of the country, and it is duty of the state to follow those principles in the governance of the country. Rights and duties are correlative to each other. Therefore, to follow fundamental duties is an obligation of every citizen of this country. No doubt, every constitution is for good government, and if the people who are running the government are not good, then it would be great danger to legal system of the country. Therefore, it is expected that while running a government, an intention of the framers of the Constitution of India is to be considered in the letter and spirit. So students, I hope in this lecture you have got a detailed idea about Constitution of India. If you have missed any of the lecture in this series or modules, you may log on to our website, that is www.cec.nic.in, for frequently asked questions and assignments and many more. I will again meet you in another session with more learning lectures in coming episodes. So till then, keep learning. Thank you.